All right, good afternoon, ladies and gentlemen. My name is Judge Lal, and we're going to begin with our state expedited accusation calendar with the Fulton County State Court. These are a list of criminal misdemeanor cases in which individuals have been, folks, I'm just going to have to take a minute. I'm having a couple of technical issues. Sorry about that. Okay, no, that fixed it. All right, thank you. As I was saying, this is a list of misdemeanor cases in which individuals have been charged with certain misdemeanor offenses and been booked at the Fulton County Jail. Upon being booked in, the prosecutor, which is the Solicitor General's Office of Fulton County, has already accused the defendant with one or more misdemeanor offenses. This would be hence the defendant's initial appearance before a judicial officer. When I call your name, I will let you know who is going to be representing you. I'm sorry, Mr. Jordan, are you able to see and hear me?
I can hear you, Jeff. It pauses every once in a while.
All right, I don't know what's, my Odyssey just closed out on me, so sorry about that. Okay, as I was saying, this would be the defendant's initial appearance before a judge, at which time I will let you know what's your case number, what are the charges that have been brought against you, to appoint counsel to represent you, as well as to set a bond. For some of you, you may receive a new court date as well. Presently, our reset date is going to be May 25th, 2023. Would that be correct, Mr. Jordan?
Yes, Your Honor.
All right, thank you. For those of you charged with a misdemeanor offense, I would like you to keep certain things in mind. First of all, you have a right to remain silent. Anything you choose to share with the court in this open proceedings, which is not only recorded but live streamed, your statements can and will be used against you. Please exercise your right to remain silent and let your attorney speak for you. You do have a right to an attorney. If you cannot afford one, one will be appointed to represent you. At the present time, we have position number 3 in courtroom 2. Would that be correct? Is this Ms. Kim Brown?
Judge, you are really good.
Thank you.
Yes, this is position number 3.
All right, thank you. This is case number 23 CR 002940J. This is Ms. Kate State versus Kim Brown, accused of 1 count of reckless conduct and 1 count of battery domestic violence from May 12, 2023. Ms. Brown, you've been advised of your right to remain silent, and your attorney is Ms. Elizabeth Hogue. Mr. Howard, do we have any priors on Ms. Brown?
Hold on. I only got 1 Brown on my pool of sheets. Hold on.
All right.
Your Honor, Ms.
Yeah,
Brown,
I only have Justin Brown. I'll let the state go.
I'm not showing any prior history for Miss Kim Brown.
All right. And what's the state's recommendation?
Your Honor, due to the fact that Ms. Brown did fire a weapon inside of a house, which the state has some serious concerns with, being that this happened in the proximity of her brother, James Brown, we have some serious concerns about the likelihood of not only the danger that presented, but the likelihood of reoffense. Additionally, we have some concerns about the 2 of these individuals, James Brown and his sister, remaining in the same household at 1040 Beechcrest Road in Atlanta, due to the fact that there was a fight at that location that resulted in injury to Mr. Brown. For those reasons, the state is recommending a $10,000 surety bond. That's $7,500 for the reckless conduct, $2,500 for the family violence battery. We are also asking for a stay away from that location at 1040 Beechcrest Road in Atlanta. No further contact with James Brown, no alcohol, drugs, or weapons. Specifically, we're asking that she surrender all of her weapons, all of her firearms, to the sheriff's office. Again, we do have some concerns, being that this happened in the presence of a 3rd individual, the locksmith, who had to call the police.
All right, thank you. Ms. Hope?
Yes, Your Honor. Ms. Brown, as you can see, is 63 years old and she has absolutely no history whatsoever, Your Honor. She was born and raised here in Georgia, went to high school and college, got a degree in mathematics, where then she did ultimately move to California, where she worked for the city of LA for a couple of decades, actually, as well as setting up her own home care business as well. She raised two daughters, twins, who are both 29, Your Honor. So she's a very successful person in general. She is here taking care of her mother. The person who owns the house is the mother. She has dementia as well as other issues, blood clots, everything else. And she was requested to come here to take care of her mother because she's the one who seems to be able to take care of her the best, to get her to her doctor appointments, to do everything. She's also appointed her executor. So she is her mother's primary caregiver. She's her mother who takes her to the hospitals and everything else. So, Your Honor, for her to say, ask her to leave would be unconscionable because her mother would not have the kind of care that she would need.
Isn't James Brown an occupant of the property?
He's an occupant, but he does not take care of the mother. In fact,
That's not what I asked. I simply asked whether the alleged victim is an occupant of the property.
Yes, he is also staying there. He is the son. There's the mother, there's a brother who's currently in the hospital, and there's her, and then the other Mr. Brown. So
And this whole incident apparently began through an alleged self-help to have him removed from the property?
No, this alleged incident happened from this. There was an issue that the mother wanted resolved. She had concerns about, shall we say, some things happening with one of the brothers who was locking his room. The mother who owns the house asked to have her daughter, Ms. Brown, Kim Brown, have a locksmith come over and open the door. This was not there's a couple of Mr. Browns here, so let's not get confused here.
I'm only talking about James Brown.
James Brown's room was not being even touched. It was the other brother who the mother wanted the room checked because she was missing items and had concerns that those items were in that room and that brother was not allowing her in.
All right.
Okay, and it wasn't Mr. Brown's room, so he had no business even being concerned about it.
Let's talk about the weapon then.
The weapon was, now, I think that one thing the ASC or DC, Ms. Falk didn't talk about is that Ms. Brown went to the hospital. She was attacked as well. She had marks, she had injuries.
I understand both of them went to the hospital.
No, the one I'm saying one's in the hospital. It's an older brother who's been in the hospital for a while. Mr. James Brown, the alleged victim in this case, was not taken to the hospital. He was checked and not taken to the hospital. She was checked and taken to the hospital.
Okay.
Okay. So she was in fact taken to the hospital due to their concerns for her injuries. She was attacked, Your Honor. So it's questionable as who attacked who first, and she acted in self-defense. Now she is there taking.
I'm sorry. How was that self-defense?
Well, when you're a woman,
when the weapon was discharged, was it directed at the
I don't think
cross defendant?
No one really knows exactly what happened in that regard. There's not been actual testimony in it.
Okay.
Well, Your Honor, they did collect not only a handgun, but a live casing and a live round and casing. According to the defendant, she said she fired the gun outside. According to Mr. Brown, he stated she fired the gun inside the house. Either way, she admitted that the gun was fired after the altercation, not during.
Well, no, she admitted that she fired it in self-defense to stop the altercation, which apparently it did.
Let me see. I've read the warrant, so I'm a little perplexed by the conflicting views.
Well, I think it's because both have their own story.
Right. All right. What else do you have, Ms. Hope?
Your Honor, and like I said, she is the primary caregiver. She's the one that takes care of her mother, all the medical needs inside the house as well as out. That was one of the problems. The brother is not capable, I guess, of doing all the things necessary for the mother, even at the home care, as well as getting her mother to the hospital appointments and to all the doctor appointments. And so at this point, Your Honor, first off, I do believe a signature bond is more than warranted. She is a smaller woman attacked by a larger man. Okay, she went to the hospital, he did not. She is the primary caregiver. Okay, Your Honor. So I do believe that she's the one that should be allowed to stay as well, because she's the person who's taking care of the mother. As far as the weapon goes, I did tell her that she would need to surrender her weapon. She said that's fine. She has no problem doing that, Your Honor. And so I do believe that, and not only that, but she also takes care of the animals that are there. There are 6 puppies and 2 grown dogs that she also cares for there. So she is the primary person there. So we do believe that a signature bond is more than justified, and that if anyone has to move out, it would be the other brother, Mr. Brown, not her.
And
Yes,
what
it
is Mr. Brown's full name that you believe to be the alleged victim?
James
Cross
Brown.
defendant, James Brown. As
James
long as you and I are on the same page about that. Thank you.
Yeah, I think there's a problem because there's 3 Browns, 3 or 4 Browns in that household.
Understood. Thank you. So we do have very diametrically opposite points of view, one from the alleged defendant, one from the alleged cross-defendant, one from the alleged witness, the locksmith, as well as what information is provided in the warrant. On the reckless, but one thing is undisputed, is that Ms. Kim Brown did discharge a firearm. And for purposes of self-defense, that is the ultimate issue for a jury or a trial fact to decide. The bond for the reckless conduct is a $2,500 surety bond. For the battery family violence is a $5,000 signature bond through pretrial services. Ms. Kim Brown is to have no further contact with Mr. James Brown. I understand Mr. James Brown has also been was also charged and released on copy of charges. So I gather that matter would have to be addressed either in the city of South Fulton or in Fulton County State Court. With regards to the stay away, at the present time, she is to stay away from 1640 Beechcrest Road in South Fulton. Now, if Mr. James Brown has been vacated from the premises, either voluntarily, he vacates the premises, or he is removed from the property through a proper dispossessory action, then Ms. Kim Brown may return to the property. She may return to the property one time only with a police officer to retrieve her personal belongings. Within 30 days of being released, she must update the court with her new address.
Your
Now,
Honor, I'm sorry, but you will put the mother at risk. You're putting her mother at risk.
Ms. Hogue, I am putting I consider that some risk. I consider the alleged use of a firearm a greater risk. As I was saying, she does, as you just mentioned, she does have another son living there, James Brown.
No, she has another son who's in the hospital.
But she has one other person called James Brown living there. And according to
Yes,
the
but
warrant,
Mr. Brown is not taking care of the mother. That was one of the problems.
Ms. Hogue, I do not know that. All I do know is the circumstances of the bond. And I've already laid out the fact that I had diametrically opposite views from 4 different points of view. And so this is the bond. As I was saying, if Mr. James Brown is removed from the property either voluntarily or through a dispossessory action, Ms. Kim Brown may return to the property. Of course, if there is a medical issue with regards to the mother of Brown, then there would have to be a medical intervention in the process. So at the present time, due to the circumstances of this entire case, this is the court order. Her next court date will be sent to her at her new address, which she must update the court within 30 days of being released. Thank you.
Your Honor, really quickly, did Your Honor add the surrendering any firearms?
Oh, yes, I'm so sorry. Yes, she needs to surrender all firearms to be surrendered to the authorities for destruction. I beg your pardon. Her next court date is going to be May 25th, subject to her release. Thank you. Next case, please.
Next, Your Honor, we have position number 4, Ms. Crystal Castle.
This is State versus Crystal Castle, 23 CR 002925Y. Ms. Castle, you've been advised of your right to remain silent. Your attorney is going to be Ms. Hogue, and your charges are battery, domestic violence from May 12, 2023, involving I don't know whether this person's a minor, so I'm just going to refer to as NG. Mr. Howard, any priors?
second arrest, 2003, theft by unlawful taking and theft by receipt.
All right, thank you.
Your Honor, if I may ask, can the jail also bring forward Ms. Siobhan Murray? They are actually co-defendants on this case, position 16.
Ms. Murray?
They're ready, Your Honor.
All right, thank you. Ms. Murray, you've been charged with battery from May 12, 2023, and your case number is 23 CR 002-926Y. Ms. Murray, your attorney is Ms. McLeod, and your charge has been 1 count of battery. Mr. Howard, any priors on Ms. Siobhan Murray?
First arrest, resident of Philadelphia, Pennsylvania.
Thank you. All right, Ms. Hogue and, excuse me, Ms. Fall, what's your recommendation for Ms. Castle?
Yes, Your Honor. And I will say that Ms. Gill is 31 years of age. This occurred based on an argument that Ms. Castle and Ms. Gill and Defendant Murray were all having. Defendant Castle is Ms. Gill's mother. Defendant Murray is Ms. Gill's sister. Apparently, there were derogatory remarks being said by Defendant Murray about Ms. Gill's son. Ms. Gill confronted the Defendant Murray. Defendant Murray then punched Ms. Gill in the face. Defendant Castle broke up the fight. Ms. Gill went back to her room, began speaking to her father, called Defendant Castle, her mother, a name. Defendant Castle then intervened and began punching Ms. Gill in the face. Everyone was separated again. Ms. Gill went back to her room and then heard Defendant Murray talking about her, came back out, and then a fight again ensued between all the parties. At one point, according to Ms. Gill, Defendant Castle held her down while Defendant Murray began pulling her hair and kicking her. Officers were able to observe a knot to Ms. Gill's forehead and one of her braids that had been pulled out. Defendant Murray did admit in the police report that we received to striking Ms. Gill in the face and pulling her hair while Ms. Gill was being held down by Defendant Castle. And Ms. Murray had no injuries that were visible to the officer. Defendant Castle did have a bruise and a scratch. The state is asking for both parties a $3,000 surety bond, one-time law enforcement escort to ensure that Ms. Gill is no longer at that address. According to the police report, Ms. Gill was in the process of moving out when this all happened. No further contact with Nilaja Gill, that is Nilajah, Gill, 1 day anger awareness for both parties, and no alcohol, drugs, or weapons. That's all for the state.
All right. Do you know if Ms. Gill has vacated the premises?
I do not, and that's why I was requesting that one-time law enforcement escort to see if she is at the premises still. We would also like to sound for Ms. Gill. I don't see her on here, but I do see a Keela Hamid Lockett, and I'm not sure who that individual is.
Nilaja Gill? All right. Ms. Hogue, what is your recommendation for Ms. Castle?
Your Honor, to put all this in perspective, none of these people live here in Georgia. They came here, Miss Gill, the mother and the 2 daughters, okay, all came here from Philadelphia. They're staying at an Airbnb. Miss Gill has already left the Airbnb, so she is already gone. So this is not a place that any of them stay. They will all need at least one time to go back and get Miss Murray, I'm sure Miss McLeod will say, they'll need to go back and get their things out of there, but they also all have flights scheduled for tomorrow, and I believe Miss Gill has already left back to Philadelphia. In Philadelphia, Miss Gill does not live with her mother or her sister, so obviously any stay away is not an issue because they don't live together in Philadelphia. Okay, as far as this goes, this apparently was some kind of a family fight, some kind of argument. I'm sure everyone's got their own side on this, okay? And who did what and who fought what. Okay, so to give you some background on Miss Castle, Your Honor, she is an administrative assistant at the Albrington Friends School for the last 6 years. She has a high school as well as a college education, a CC from Philly, AA in business administration. She has, 3 adult children. These are 2 of the girls. She was here, like I said, they were all here. They got in some kind of an argument. Who knows how it all started? However, I do believe, given her lack of criminal history, the last thing being something from 20 years ago, that a signature bond is not unwarranted. I believe that there's no issue that she would appear for court, Your Honor. She has a career, she has everything, she has every reason to resolve this. I'm sure Ms. Murray has the same thing. So we're just asking for a signature bond at this time. And if there's a need for a one-time escort for them to go back to the Airbnb to get their belongings as well. But my understanding is that Ms. Gill has already left.
All right, thank you. Ms. McLeod, I'm going to be issuing a signature bond. Did you have anything else to add?
No, Your Honor, just to point out that my client has
Oh, Ms. McLeod, your Wi-Fi is not allowing audio to come through. You may want to switch off your video and maybe the audio will be able to come through. All
Yes,
right.
Your Honor. I was saying that my client she has no criminal history and she's gainfully employed as a teacher. So she will come back or court. She has no issue with that, Your Honor.
All right, thank you. On Crystal Castle, that's going to be a $3,000 signature bond through the jail. And no further contact with Nilaja Gill. And she needs to make sure she updates the court with her current mailing address so that we can send a notice of when to show back up in court in Fulton County State. No weapons, no illegal drugs. And as I said, no further contact with Nilaja Gill. If there are any future altercations with Miss Nilaja Gill and she gets arrested, whether here or in Philadelphia, that information tends to go nationwide. So she's instructed to act accordingly. She may return to 865 Sandy Creek Drive one time only with a police officer to retrieve her personal belongings. Otherwise, she's to stay away from that location. Same bond for Miss Murray, and that's going to be a $3,000 signature bond through the jail. No further contact with Nilaja Gill, to stay away from the 865 Sandy Creek Drive, and may return there one time only with a police officer to retrieve her personal belongings. Otherwise, she needs to make sure that she returns to court when summoned. So it's very important that she maintains a current mailing address with the State Court of Fulton County. Thank you.
Your Honor, that concludes my business.
Yes, Ms. Cloud, you are fading out now. So have a good week and happy Mother's Day. Thank you. Next case, please.
Thank you, Your Honor. Thank you.
Next, Your Honor, we have position number 6, Ms. Cooks.
This is State versus Finis Cooks, 23 CR 002927D. Ms. Cooks is accused of battery from a May 12, 2023 incident. Ms. Cooks, you've been advised of your right to remain silent, and your attorney is Ms. Hogue.
First arrest.
All right,
No.
thank you. Ms. Falk, any recommendation? I'm sorry, you're on mute.
Yes, Your Honor. This incident happened when Jarvis Wilson stated his girlfriend, the defendant, attacked him. He did have injuries that the officers observed to his face, chest, and shoulder area. The defendant did admit to putting her hands on Mr. Wilson, and the officer saw blood from an injury under Mr. Wilson's left eye. Although this is the first offense, the state is concerned about the fact that the two of them do need to be separated. To that end, we are requesting a $3,000 surety bond, a stay away from 1010 Forest Overlook Drive, excuse me. No further contact with Jarvis Wilson, 1 day anger awareness, no alcohol, drugs, or weapons. We would like to sound for Mr. Jarvis Wilson.
Mr. Jarvis Wilson? All right, Ms. Hogue?
Yes, Your Honor. Ms. Cook is 34 years old, Your Honor. She's been in Georgia. She grew up in Philly, so this is another Philly person. However, she moved to Georgia 6 years ago, where she has been working self-employed as a dancer for the last 5 years. She went to high school. She has a high school degree as well as training in nursing. So she does have skills and everything else, Your Honor. She also has one son, 2 years old, by the name of Ferris, that right now is at the residence where this happened and is right now being cared by the alleged victim in this case. So right now, they both live in the house together. It's a rather sizable house. She would like to be able to remain there at least so that she can find additional housing as long as she's got her son and he takes care of her son while she works, Your Honor. So there is a situation like that. So we are, number one, she has no criminal history, Your Honor. This is an isolated incident. So we are asking for a signature bond of this and just a no further violent contact.
$2,500 signature bond through pretrial services. No further contact with Jarvis Wilson. She needs to stay away from 1010 Forest Overlook Drive, at that location. She may return one time only with a police officer to retrieve her belongings and her child. And she'll need to update the court with her current mailing address. I'm assuming it's going to be somewhere in Atlanta or in Georgia. If she does leave the state, she will need to make sure that she notifies pretrial that because she is still required to report in person to pretrial. And if she leaves the state, she would need court order and a court order permission so that we can address her pretrial report requirements. No illegal drugs, no alcohol, no weapons, and she will get notice for her next court date. Thank you.
Your Honor, the state did request 1-day anger awareness.
All right, she will need to do her 1-day anger awareness program through pretrial services. Next case, please.
Your Honor, what was that bond amount?
2,500 signature bond through pretrial. She cannot return to the location. One-time visit with a police officer to retrieve her belongings and her child, and to stay away from Jarvis Wilson.
Thank you. Next, we have position number 15, Ms. Tanika Monroe.
Ms. Monroe is accused of trespass from May 12, 2023 in case number 23 CR 002-934Y. Ms. Monroe, you've been, your attorney is going to be Ms. Helen. You've been advised of your right to remain silent. Mr. Howard, any priors?
Third arrest, last was 2011, a traffic offense in Texas, and an 08 marijuana conviction. That's
All right.
it.
Thank you. Ms. Falk?
Yes, Your Honor, the state extended an offer to Ms. Monroe. Ms. Helen just texted me in the chat and said she wished to convey that offer to Ms. Monroe. So if we could move on to a different individual other than, because there's another outstanding offer that needs to be discussed with their client, other than Justin Brown, we're prepared to go forward.
Ms. Helen?
That is correct, Judge. I have Ms. Monroe there. I just want to relay an offer that I do believe she's going to take this afternoon. And if we could just go to another case, I think she'd take that plea offer.
All right. To whom will the paperwork be sent?
Your Honor, I'll be sending it to Sergeant Norris and PD Helen.
All right. Thank you. All right. Sergeant Norris, we're going to address Ms. Monroe, and I think another person was Justin. Was it Justin Allen?
It was Justin Brown.
Justin Brown.
Justin Brown. Okay.
I already have the paperwork for Justin Brown. It's already filled out. I just have to get it sent over.
Yeah, I've already spoken with Mr. Brown about the offer. I let Ms. Falk know that. So he's going to be taking the offer.
I just didn't have a chance to send it over. Do you still want to address the case, Your Honor?
Mr. Jordan, do you have the paperwork for Justin Brown?
I didn't send it over yet, Your Honor.
Okay, then we'll wait until the paperwork is with Mr. Jordan. Thank you.
We'll see that now.
Next case, please.
So we'll go to position number 5, Mr. Coley, Rodriguez Coley.
Rodriguez Coley. All right. I do notice that there are people who are waiting to speak in support or against a particular defendant. And if you are waiting, you will be given an opportunity to speak when that defendant is called to the screen. All right. Thank you. Mr. Coley is position number 5, accused of 3 counts of battery, domestic violence from July 21st, 2021. This is case 23 CR 002-928Y. Mr. Coley, you've been advised of your right to remain silent, and your attorney is Ms. Hope. I do see a Miss Koshan Calloway. She is present as well. Mr. Howard, and how many priors with Mr. Coley?
14, Last arrest was last month, suspended license, theft by receiving. He got a 2020 sale of marijuana, obstruction, 2018 probation, 2016 probation and marijuana, and a 2014 trespass battery conviction. That's it.
Thank you. Ms. Falk, there are 3 counts of battery. Was there one warrant or did I skip a couple?
There was originally one warrant. However, the state received a police report which went into far more detail in regards to what happened on this evening.
All right, please enlighten us.
Yes, Your Honor. So this happened July 10th, 2021 at 390 Stovall Street in Unit 3008. Ms. Quashawn Calloway, who Your Honor correctly pointed out is here on the Zoom, told officers that her neighbor made a 911 call and then she called 911 a second time. She stated earlier in the evening she was out with her friends, her car window got busted out. She called the defendant by accident, who then began calling and texting her repeatedly. She then told police that the defendant lives at the location of Stovall Street and they had been together for approximately a year. She said when she arrived home at about 2 o'clock that morning, the defendant used his keys to enter her apartment, pulled the covers off her while she was in bed and began assaulting her. She told police that he grabbed her, choked her, and hit her head against the floor. The officers observed the apartment in disarray, the door off its hinges in the bedroom. Ms. Calloway had a braid ripped out of the front of her head that the officers observed, red marks on her neck, and there was blood on the toilet. Ms. Calloway was also transported to Grady because her voice was hoarse, there was swelling beginning in her neck, and she had a potential head injury, according to the EMTs. We have had an opportunity to speak with Ms. Calloway. She stated that she and the defendant have been together for now 3 years and do live together at that address. They have no children, and she has basically stated she does not want to go forward at all on this case, and everything has been good since this incident. However, the state would like to point out that in the 14 cycles, the defendant has a probation violation arrest from 2016, 2018, and most notably was sentenced in September of 2014 to 24 months probation, DV program, and a stay away from 3303 Tree Hills Parkway in Stone Mountain for a battery and a criminal trespass. And that was 14C71844 out of DeKalb County. For those reasons, the state does have serious concerns about a risk of reoffense here. Although this case did happen almost 2 years ago, that concern has not gone away based on the severity of the injuries that were placed into the police report and the fact he has this prior battery for which he was given DV programming. For that reason, we asked for a $9,000 surety bond. That's $3,000 per count. Stay away from 390 Stovall Street, Unit 3008. No further contact with Quashawn Calloway. No alcohol, drugs, or weapons, and we are requesting FFIP. Your Honor, Ms. Calloway is here and I believe would like to speak.
All right, thank you, Ms. Hope. Ms. Falk, thank you. Ms. Calloway, my name is Judge Lal. If you would like to make any comments, first of all, please place your hands down from your face. And if you'd like to make a comment, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
What would you like to tell me?
First of all, good afternoon, Your Honor. When this incident occurred, I would like to say that we were intoxicated, we were drunk, so I don't remember exactly what happened into details, but I would like to say that we haven't had any altercations or any arguments since then. We are actually planning on getting married and having a baby soon. I didn't want to proceed on pressing any charges. I haven't had any problems with him since then. He helps me daily, helps me take care of my home. And yeah, it's people make mistakes. I feel like it was just a mistake. We were early on in our relationship. Now we're at 3 years going on 4. We haven't had any more problems since then. So, I mean, I don't want him to be incarcerated for this. At the time, I was drunk and I just wanted to get him away from me. But that's all I wanted to say. I don't fear for my life around him or anything. I actually love him, but yeah.
Thank you. Mr. Howard, I understand that Mr. Rodriguez also has a Henry County hold. Can we confirm that?
Yeah, hold on. This is who?
That is correct, Your Honor. I'm looking at the jail screen now.
All right, thank
Hold
you.
on. Who is this? Who we on, Judge?
Rodriguez Colley, position
Colley.
number 5.
All right, let me see if I see what it's for. It's a probation violation, dangerous weapon.
All right, thank you. I just needed to confirm the whole. Thank you. Ms. Hope,
Yeah.
anything else to add?
Yes, Your Honor. Mr. Coley is 28 years old. He is born and raised here in Atlanta, Georgia. He has significant family ties here. He has a family business that he works in that his grandfather started, blinds and window installation that he started working in before he even left high school. And when he left high school, that's exactly what he did. He's gone in and he works in the family business as well. So he has significant family ties here. He works, as noted here, what I think was most important is that there was a 2014 incident when he was obviously about 18, 19 years old, Your Honor, that is 9 years old now, that was 7 years old even when this alleged incident happened. As you can hear Ms. Calloway say, nothing has happened. This has been almost 2 years since this incident allegedly happened, and they are just fine now. They are getting married. They're going to have a child. They're working well together, and they have been together since then. So I would ask, I believe a signature bond is warranted in this case, and that they just have no further violent contact. I understand that while they do also spend a lot of time together, he even does have a separate address. So, but they also spend a lot of time at that address as well. So they kind of, spend their time between the two addresses. So that's all I'm requesting at this point in time, Your Honor.
On each count, it will be $2,000. It's going to be a signature bond through pretrial services. That's a $6,000 signature bond through pretrial services. No further violent contact with Miss Koshana Calloway. That's no further violent contact. No illegal drugs, no alcohol, and no weapons and no firearms. Mr. Colley, within 30 days of being released from the jail, within 30 days, that's 1 month, you are to enroll and complete a domestic violence intervention program again. As you know, that is a 24-week program, and you are to show your attendance to those classes every time that you report to pretrial. You'll be required to report to pretrial once a month. You will also be subject to random screens for alcohol and or drugs, and your next court date will be sent to you at your current mailing address. And the mailing address that we have is
See, that's so weird that it does that.
oh, sorry, Miss Helen, you're
Oh, sorry, Judge.
okay. The current mailing address we have is Karen Lane, is that correct? All right, if that's your current mailing address, you better make sure that it is, otherwise you'll need to update it with the court and with pretrial. Thank you.
And Your Honor, based on the prior history and the severity of the injuries, we do object to a signature bond.
Noted, thank you. Next case, please. Oh, I'm so sorry, Mr. Colley. I'm so sorry. I forgot one other thing. I do beg your pardon. I do beg your pardon. The $6,000 signature bond is through pretrial services. Once pretrial has interviewed him, he will be only released to the Henry County hold. So he has to wait till Henry County comes and picks him up. I forgot about the hold. All right. Sergeant Norris, please make note that he can only be released to Henry County enforcement, law enforcement.
Gotcha, Your Honor.
Thank you.
All these are per judges too.
Yes, sir.
Next, we have position number 11, Miss Xaviera Holiday.
Ms. Holiday is accused of terroristic threats and acts from May 12, 2023 and disrupting a public school. Her accusation number is 23 CR 002942G. Ms. Holiday, you've been advised of your right to remain silent, and your attorney is going to be Ms. Holt. Any priors, Mr. Howard?
Judge, that wasn't on my pull sheet. I don't know how people keep getting added, but
Ms. Falk, would you be able to give us a prior list?
I can, Your Honor. The defendant's history consists of 9 cycles Her most recent arrest is a driving while license suspended in 2022. That was null prost. A simple battery from 2012 out of Union City Municipal Court, battery out of 2005 out of Fulton County. I know that was dismissed. A probation violation out of 2005 out of Cobb, criminal trespass 2004 in Cobb, and a battery, simple battery that was dismissed in 2003, a reckless conduct ag assault, I believe that was dismissed as well in 2003, probation violation in 2002, and a insurance, false proof of insurance in 2001. That is all.
All right, thank you. And your bond recommendation?
Your Honor, due to the facts of this case, our bond recommendation and the lack of history, I will say she has had between the suspended license and her dismissed battery has been 10 years. We are recommending a $4,000 signature bond, $2,000 per charge. Stay away from 545 Hill Street in Atlanta, which is MLK Junior Middle School. My understanding is that they did give the defendant a criminal trespass warning, so she's not permitted to go back to the school regardless. No further contact with Shaquilla Edwards. That was the instruction coach who she threatened to whip her ass. And then 1 day anger awareness and no alcohol, drugs, or weapons. This seems to have begun because a threat had been made to her granddaughter via text, not from any of the parties who were involved in this, but apparently Miss Holiday became very upset and began yelling at instructional coach Shaquilla Edwards.
All right, thank you. Ms. Ho?
We don't have any problem with the prosecution's recommendation, Your Honor.
All right. Ms. Falk, I'm so sorry, I forgot to write down the figures. I was so busy writing the GCI.
4,000, 2,000 per
Please,
count
okay,
for pretrial.
It's a $4,000 total signature bond through pretrial services. No further contact with Shaquilla Edwards. She's to stay 200 yards away from Miss Edwards and not communicate with her in any way, including in person, through a third party, through any kind of electronic device, or even on social media. She's to stay 200 yards away from the entire middle school, referred to as Martin Luther King Junior Middle School. If she has any child or children or relatives attending that school, she's not permitted to return to a step in the school premises. Any communication would have to be done from the school staff directly to Miss Holiday. And that communication could be done via email, via phone call, or even through notes to the student in question. No illegal drugs, no alcohol, no weapons, and her next court date will be sent to her at a current address. If her address changes, she will need to make sure she updates the court with her current mailing address. Thank you.
And the state did request 1 day anger awareness.
This is not a DB case, so I'm not going to order that. Thank you.
Your Honor, I apologize. What was that bond amount?
2,000 each count is a total of $4,000 signature bond through pretrial. If she violates the conditions or if she gets arrested again, the bond will be converted to a surety bond or a cash bond. Thank you.
And Your Honor, I did send the paperwork for Justin Brown and Tanika Moore to Mr. Jordan. I just hit send, so it may take him a moment, but we are ready to go forward on both
All right.
cases.
I sent them to.
All right, good. Sergeant Norris, may we have anyone else but Brown or the other plea?
Okay. Can we go to position 18 and position number 19, Ms. Patricia Sullivan?
And Your Honor, I am requesting a breakout for positions 18 and 19.
All right, and who's going to be in the breakout?
Just me, Your Honor. Well,
All right.
any one of Miss Helen's choosing.
And Ms. Hogue as well, sure, Ms. Hogue as well.
Mr. Jordan, could you please place us in the breakout? And Ms. Sullivan, you've been reminded of your right to remain silent, and your attorney is Ms. Helen, and we'll be with you shortly. Thank you. Courtroom 2. Miss Lee, are you reclining in a bed? Because if you are, you need to get out of bed and go sit at a table and chair. Thank you. All right, returning back to Patricia Sullivan. Ms. Sullivan's got 2 cases pending before us. The first one is 23 CR 002-937E, in which she's accused of theft of services on March 17, 2023. The second case against Ms. Sullivan is 23 CR 002-938E, in which she's accused of theft by shoplifting from a Target store, allegedly on March 23rd, 2023. Ms. Sullivan, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. Based on the information and your criminal history record, especially in the last couple of years, bond is going to be set on the theft of services for $750. It's going to be a surety bond. You are to stay 200 yards away from the C&S Oyster Bar at 6125 Roswell Road in Sandy Springs. With regards to position number 19, case ending in 2938, the theft by shoplifting, your bond is going to be set at $1,000 surety bond, and you're to stay away from the Target store at 3535 Peachtree Street in Atlanta, Georgia. Your next court date for both cases is going to be May 25th at 9 a.m. Thank you.
Next, Your Honor, we have position number 1, Mr. Kerry Adams. Position number 1.
This is State versus Kerry Adams, accused of battery, domestic violence, and accusation number 23 CR 002-923C. Mr. Adams, you've been advised of your right to remain silent. Your attorney is going to be Miss, I believe it's Miss Ho. That's right.
Yes, it's me, Your Honor.
Sorry, these little boxes keep moving around. So, okay, there we go. And Mr. Howard, any priors on Mr. Adams?
21 total. Last arrest was last month, simple battery, family violence. Got a 2022 battery DV, cruelty to children and hindering, that was dismissed. 2020 probation, 2019 simple battery DV dismissed. 2014 fraud by wire conviction, and a 2013 simple battery conviction.
Thank you. Ms. Falk?
Yes, Your Honor. This happened May 6, 2023 at 6 p.m. at 2580 Fox Lair Trail. Octavia Stevens told the police that her child's father, the defendant, was in a verbal altercation with her when he threw an object at her and then punched her in the left eye with a closed fist, resulting in visible injury to her eye. He then fled when she called the police. So the problem that I particularly have as a state with this case is that we have multiple arrests for simple battery family violence involving the defendant and Octavia Stevens. In fact, the 2012 case, which was 12 CR 390222, the 2013 case, which was 13 CR 392008, and the 2015 case, 15 CR 001334, and the 2019 case, 19 CR 009645. 009, yes, 645Y, all involved the defendant and Octavia Stevens in a domestic violence case, all of which were dismissed, or one was found not guilty. That was the 2012 case because of lack of cooperation from Miss Octavia Stevens. The 2022 case, which was dismissed for lack of participation by the victim, involved Corinne Stevens, who was his daughter, and that was the 22 CR 005618Y case. There is essentially an established pattern here of arrest involving domestic violence against Octavia Stevens. We have serious, grave concerns about the safety of Miss Octavia Stevens if this continues on this trajectory, and a real serious concern about the risk of reoffense here. For that reason, the state is asking for a $10,000 surety bond. Stay away from 2580 Fox Lair Trail, South Fulton. No further contact with Octavia Stevens, because we are very concerned about a continuing contact leading to yet another time Ms. Stevens will not cooperate with the state family violence intervention program, and no alcohol, drugs, or weapons.
All right. Ms. Hope?
Yes, Your Honor. Mr. Adams is 47 years old, Your Honor. He's a lifetime resident of Georgia. He has a high school education, and he has worked generally in, shall we say, traffic, construction area things where he now, a lot of the construction stuff he does is direct the traffic around. Your Honor, so, but he was recently laid off, so now he's just doing pickup jobs, so he has extremely limited finances. As far as it goes, he also does warehouse work and just, anything he can pick up right now to make ends meet. He and Miss Stevens do not live together. In fact, this was happening at a house at a family type situation. So I've already discussed that with him and explained to him that he cannot have contact with her. He has no problem with the no contact, Your Honor. And that if there's some kind of family gathering, they're going to have to figure out who can do what and who can show up for what and how they can show up. But they know, so that seems to be where some of this stuff comes from. They do not live together as it is right now. In fact, I don't believe that address is either their address. I think that's the address of one of the daughters. So right now, Your Honor, but he has extremely limited income. So one, I have concerns that he could even make the bond. So I know he does have a history, but a lot of it was dismissed, Your Honor, for whatever reason you can say, but it was dismissed. And given that, I don't believe the signature bond is unwarranted or a low bond. At that point, the problem I have is I don't mind the anger awareness, Your Honor, but already family violence intervention, when he's only bringing in maybe $600 a month right now, I don't know if he could actually realistically afford it at this point. Okay, so I would have concerns about trying to even put him on that path at this point. Maybe it's something that can be discussed as he moves further in, even before the case is resolved, trying to start something like that. But I have concerns of putting him in a financial situation until he gets a more stable job situation. So like I said, we are asking for a signature bond, if not possibly a low bond of like $1,000 surety. And the no further contact is not a problem, and the stayaways are not a problem.
All right. Bond is set at $10,000. It's a surety bond. No further contact with Octavia Stevens, to stay away from all locations where she happens to be. I'm not sure if this Fox Layer Trail is a location where Miss Stevens visits, because apparently that might also be her daughter's place. So I'm going to require him to stay away from 2580 Fox Layer Trail in South Fulton. Mr. Adams is to stay 200 yards away from Octavia Stevens, not communicate with her in any way, form, or manner. I'm going to put in a bond order, there shall be no modification of this bond order unless we have a hearing in person with Miss Octavia Stevens' presence. So Mr. Jordan, please be mindful that any bond modification hearing must be in person and with the presence of Miss Octavia Stevens. No illegal drugs, no alcohol, no weapons. Next court date is May 25th. Thank you.
Your Honor, are we ready on the plea cases?
I gather, Mr. Jordan, do you have the paperwork?
I have
Yes, ma'am, I have
submitted the signed, or at least the completed form for Miss Rowe, Your Honor.
Right, whoever we have first, and that was Miss Castle?
No, Miss Monroe, Tanika Monroe, Your Honor.
Monroe, sorry.
Position 15.
All right, got it. This is State versus Tanika Monroe, 23 CR 0029341. Ms. Monroe is accused of criminal trespass at the Georgia Institute of Technology property on May 12, 2023. Ms. Monroe, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you was Ms. Helen. Ms. Helen, is the State Public Defense Office still in play, or are they withdrawing?
We're not withdrawing, Judge. Miss Monroe would like to enter in and accept the state's plea. And so, Judge, she is willing to accept that plea as a pro se representative judge.
All right. Please unmute courtroom 2. Ms. Monroe, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
And when you decided to proceed pro se or self-represented, do you understand that in doing so that you will be responsible for for understanding how the law applies to the facts of your case?
Yes, Your Honor.
And do you understand that you'll be responsible for any legal decision as to how it would impact your circumstances, how it may impact any other open cases, your possible residency, any opportunity to get a job? Do you understand all these consequences?
Yes, Your Honor.
Are you willingly and knowingly giving up your right to have a free attorney represent you?
You said, am I giving up my right?
You have a right to appointed counsel. If you cannot afford one, you can be represented by one. I'm asking you, are you freely and willingly giving up your right to have a free appointed attorney represent you?
Yes, Your Honor.
And are you freely and willingly willing to proceed on a pro se basis, knowing that any legal decision you make will be your responsibility?
Yes, Your Honor.
All right. Ms. Falk, what is the recommendation?
Yes, Your Honor. The recommendation is 12 months probation, 1 day of jail, credit for time served, 1 day release, balance suspended, stay away from all Georgia Tech property. There is currently a 2-year criminal trespass warning, trespass warning against this defendant from May 10th, 2023, ending on May 10th, 2025, that was already served on her by Georgia Tech.
Repeat the expiration date.
May 10th, 2025.
Okay. All right. Ms. Monroe, do you understand the recommendations of the plea as indicated by the prosecutor?
Yes, Your Honor.
And do you understand that you're to stay 200 yards away from all property that belongs to the Georgia Institute of Technology, what we affectionately call Georgia Tech?
Yes, Your Honor, I do. I also have belongings there.
You also have what?
I have my things there, my belongings.
What are these things?
It's inside of the police department lockers. They show me that they will be there and that
I didn't ask you where it was. I asked you, what are those things?
my backpacks, everything that I had in my possession.
So you have one backpack?
No, ma'am, I have 2 backpacks, a briefcase, a duffel bag, a straw drink, a drawstring bag, an army jacket. I think that's it. And that will be all.
How did those things end up at Georgia Tech?
I had all those things with me.
That's a lot of stuff to be carrying while you're just walking onto Georgia Tech.
Yes, ma'am. I carry those around with me.
All right. Do you agree that the location of this offense, criminal trespass, occurred in Fulton County?
Yes, ma'am.
And do you agree that the person who committed this offense is you?
Yes, ma'am. Yes, Your Honor.
And the factual basis that has been set forth by the police report and the warrants, are those all true and accurate?
Yes, Your Honor.
All right. Ms. Monroe, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
And are you entering into this plea of guilt to the charge of criminal trespass freely, knowingly, and voluntarily?
Yes, Your Honor.
Do you understand that you would have to give up your right to a trial, to go back to court, to have the assistance of counsel, to challenge the state's evidence, to present your own defenses, to confront your accuser, examine any witnesses that you are brought before you, as well as to have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of criminal trespass at Georgia Institute of Technology on May 12, 2023?
Guilty.
I repeat,
Guilty.
your sentence is 12 months to serve 1 day, credit for time served 1 day, balance suspended. Upon your release, you are to stay away from all Georgia Tech property. And wherever property belongs to Georgia Tech, Georgia Technology of Institute of Technology, you are to stay away from that property. You may return to the main police department for the Georgia Institute of Technology 1 time only with a police officer. You must have a police officer accompany you in order to return to the police station, the main police station that is where the property is located, which I'm assuming is the Georgia Tech Police Department. You may request for a retrieval of any property that they have in their lockers. If there is any dispute about the property being retrieved or there's missing property, you cannot stay there and argue that fact. You are just to accept the property that they give you, and then you must leave the Georgia Tech property. Any disputes about missing property or property that's been damaged, you may raise that in a separate civil suit, which you would have to file against the appropriate party or agency. But you cannot have an argument about any missing or damaged property while retrieving your property. Do you understand?
Yes, yes, Your Honor.
If there's any dispute, the Georgia Tech Police Department may arrest you for disorderly conduct. And you're back to square one. Understood?
Yes, Your Honor.
All right, thank you. That was the plea. Next plea, please.
So be Mr. Justin Brown, position number 2.
This is State versus Justin Brown, accusation 23 CR 002924F. Mr. Brown's accused of criminal trespass and fair evasion at a Mata property from May 12, 2023. Mr. Brown, you've been advised of your right to remain silent, and I understand that you are entering a plea. Are you freely will, excuse me, may I place you under oath? Raise your right hand. Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes.
Are you freely and willingly giving up your right to free appointed counsel?
Yes.
And do you understand that if you choose to represent yourself, that you're responsible for any legal decision you make as to how it applies to your present situation, to any other open cases you may have, to your residency, as well as to any jobs you may have?
Meaning what?
Meaning that if you have, for example, if you have an open case and you plead guilty to this, that may have a detrimental effect on any other open cases you have.
I understand, yes.
So are you still willing to give up your right to free and appointed counsel?
Yes.
All right. Ms. Falk?
Yes, Your Honor. On count 1, state's recommendation is 12 months probation, 1 day in jail, credit for time served, 1 day released, balance suspended, stay away from the Ashby MARTA station. On count 2, the recommendation is the same for a total of 12 months, 1 day, balance suspended, stay away from the Ashby MARTA station. This happened yesterday when the defendant went through the fare gate without paying at 65 Joseph E. Lowry Boulevard, and they determined he had an active MARTA suspension. And I do not have the dates on that MARTA suspension.
All right, thank you. Mr. Brown, are
Ma'am?
you aware of your active MARTA suspension?
Yes, ma'am.
And when does it expire?
Within 30 days. I'll say basically for a good reminder for me.
So you don't know when it expires? All right.
Within 30 days, within 30 days.
I don't know. I need a date.
June 12th.
All right. And do you agree that the person who allegedly committed these offenses would be you, Mr. Justin Brown?
Yes, ma'am.
And do you agree that the offense occurred in Fulton County, Georgia?
Yes, ma'am.
And do you agree that the factual basis for these charges are true and correct?
Yes, ma'am.
Right. Have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you entering a guilty plea to these charges freely, knowingly, and voluntarily?
Yes, ma'am.
And are you agreeing to give up your constitutional right to go back to court, to have a trial, to challenge these charges in a court of law, to confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt?
No, ma'am.
You're not willing to give up these rights?
I mean, I assume that's what's happening now, so I would
Did
say,
you read the documents? Did you read the documents that were provided to you?
yes, ma'am.
And what does it say about waiver of rights?
I agree to it, yes, ma'am. I recognize everything.
Repeat your sentence. I don't understand.
I said, yes, ma'am, I recognized everything.
So again, do you give up your constitutional right to a trial, to confront your accuser, examine witnesses, to challenge the state's evidence, and to have the state try to prove the charges against you beyond a reasonable doubt?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty,
How do you plead to one count of fair evasion?
guilty.
Mr. Howard, how many cycles does he have? Or Miss Falk, whoever.
Yes, Your Honor, I can pull that up.
Who we on?
It's Justin Brown. He has
20 total.
20 total, including this case. Yes, Your Honor. His last offense was a dismissed possession of marijuana in 2022. And the offense before that was a forgery in the 3rd degree, no disposition in 2020. So we did not have anything for the last 2 years.
All right. Mr. Brown, your sentence is 12 months to serve 1 day, credit for time served 1 day, balance suspended. You're to stay away from all MARTA property, just not the Ashby MARTA station. You're to stay away from all MARTA property, all buses and trains for the next 30 days or in accordance with any active MARTA suspension. I think I'm just going to put it in accordance with any active MARTA suspension. So Mr. Brown, I do not know when your suspension ends. So I would recommend that you contact the MARTA headquarters at Lindbergh Drive to make sure when your MARTA suspension ends. It could be 30 days from today, it could be longer, or it could be shorter. But if you return to MARTA property while there is an active suspension, you will be arrested again. Thank you.
You're done. Here's your paperwork.
Next case, please.
Next, Your Honor, we have position number 7, Mr. James Dewberry. Ma'am.
What?
Your Honor, I found out some information, so I'd like a breakout room on this one.
All right. Mr. Jordan, Mr. Dewberry, you've been charged with 3 misdemeanor offenses in 23 CR 002939F. You've been advised of your right to remain silent, and your attorney is Ms. Hogue. Please remain silent while we discuss your case as a sidebar. Mr. Jordan, if you could place Ms. Hogue, Ms. Falk, and myself in a breakout, please. Courtroom 2. All right. This, as I was saying, this is State versus James Dewberry. Mr. Dewberry is represented by counsel, Ms. Elizabeth Hope. Pursuant to the sidebar and the information provided, the bond is going to be set as follows. On each count of simple assault, in which there are 2 counts, is going to be $1,500 each. And that's a surety bond. On the third misdemeanor offense, that's going to be a $2,500 surety bond. And the total bond is $5,500. It's a surety bond. He is to stay 200 yards away from the Chevron at 1025 North Highland Avenue, have no further contact with the victims as identified by the state and listed in the bond order, and also to, to not consume any illegal drugs, no alcohol, and not possess any weapons or firearms. Mr. Dewberry is to stay compliant with any medical treatment or medication that's prescribed to him. And his next court date will be May 25th. Thank you.
Yeah, move that public.
It's a 2,500.
Thank you.
And Your Honor, is Miss PD Hogue, I may have missed this, is a BHET included in this, or is that going to be through PAD?
She's going to touch base with the proper channels and to verify whether an evaluation needs to be requested or whether he's already on a different track. So I cannot say at the present time.
Yes, Your Honor.
Next case, please, Sergeant Norris.
Next, we have position number 8, Mr. Eric Dozier.
Mr. Dozier's case is 23 CR 002929E, accused of simple battery from May 12, 2023. Mr. Dozier, you've been advised of your right to remain silent, and your attorney is going to be Ms. Hogue. Any prize, Mr. Howard?
Got over 30 arrests, California. He had a 2016 inflict corporal injury on a spouse or cohabitant. That was a conviction.
All right. Thank you. Ms. Falk?
Yes, Your Honor. This happened between roommates Lorinda Williams and the defendant. Miss Williams stated the defendant slapped her twice and punched her once during a verbal altercation. Livingstone ND was another person at the scene, and she, according to the warrant, it's not really clear whether she confirmed this, but she did say she saw the altercation take place. All 3 live together. Again, we are concerned about the 32 cycles out of California. State is recommending a $2,500 surety bond. Stay away from 11046 Alpharetta Highway. No further contact with Livingstone ND and Lorinda Adams, and I'll place their names in the chat for Mr. Jordan. 1-day anger awareness, no alcohol, drugs, or weapons. And this incident did happen yesterday.
All right. Does he have another case for disorderly conduct or something to that effect? I have another booking for Mr.
I can check on that, Your Honor.
All right, thank you. Ms. Hope?
Yes, Your Honor. Mr. Dozier is 43 years old, Your Honor. He did live in California for quite some time. He moved to Georgia about 3 years ago. He has an electrical engineering certificate from Honeywell Aerospace. He's been working at the process control there for 2.5 years, Your Honor. He graduated from the Pasadena High School. He does have 1 daughter already in college in Illinois State studying poli-sci. I do understand that there's some 30 counts here, but I'm only hearing about 1 count in 2013. So whatever the other ones are, they're obviously not saying much about them. My understanding is this, first off, I'm seeing a Lorenza Williams here, not so I'm a little confused in some of the names here that are going around, but my understanding is that Miss Williams doesn't live there. There are 2 roommates there. He does have a roommate there, but that Miss Williams was a visiting person, not someone living there, is my understanding. And that would not, then they're not girlfriend or boyfriend or anything like that. So we'll put to question that it is a family violence to begin with. So
I don't see accused as family violence,
The
so,
state didn't accuse it as family.
Oh,
violence,
pardon me.
Your
I'm looking at the one, I was reading the warrants as she was talking. I apologize. So it
That's
is
all
just
right.
a simple battery. Yeah, Your Honor. So like I said, that it was questionable. He lives there, but she does not. So the no contact is not an issue whatsoever. But like I said, it was his residence and the other roommate's residence, not hers. So the only thing we're asking is that even though he does have cycles, the only one I heard about was a 2013, which is 10 years old, Your Honor. And this is a simple battery, so we would ask for a signature bond, and just the no contact is fine, but that he stays where he lives because that is not her residence.
Your Honor, I will say I did take a look at the jailing record. He did receive a $1,000 surety bond, I believe on April 23rd for a disorderly, intoxicated while disorderly. Additionally, and the state didn't want to go into great detail, but the defendant does have a number of probation violations out of California, as well as that, and I believe it was a 2016 case involving abuse previously. And so the state can go over the history in more detail if Your Honor would like me to.
no, that's good. Thank you. Bond is set at 2,500. It is a surety bond. Next court date's May 25th. He's to have no further contact with Lorenda Williams. She's described as a live-in roommate according to the warrant. So I'm going to have him to stay away from 11046 Alpharetta Highway in Roswell in Fulton County. He may return to the location one time only with a police officer, and that can be a double purpose. The first purpose is to verify whether Miss Lorenda Williams lives at that location. If she does not live at that location, then he may return to the property. However, if she's still occupying the premises, then he would need to stay away from that property and update the court with a new address within 30 days of being released on his good bond. He is to also, if the second purpose of the visit will obviously be if she lives there, then he can retrieve his belongings and update the court with his new address. I don't see any other alleged victim, Ms. Falk, so I'm just going to go with Lorenda.
Yes, Your Honor. Miss
Okay.
Indy was the witness, not an
Okay.
alleged victim.
Okay. Thank you. Next case, please.
Next, Your Honor, we have Mr. Stephen Henry. That's position 10.
Mr. Henry is accused of theft by deception from a May 12, 2023 incident, case number 23 CR 002941A. Mr. Henry, you've been advised of your right to remain silent. Your attorney is Ms. Hogue and Mr. Howard. Any priors, please?
Second arrest, 2022, possession of meth, possession of drug-related objects, possession of a Schedule II controlled substance.
All right, is that still an open case? It was in Fulton County?
It's out
Cherokee
of Cherokee, and yes, it is still open, Your Honor.
All right, thank you. Miss Hope?
Want me or you want Ms. Falk?
Oh, I'm sorry, Miss Falk. Yes, sorry. I heard Miss Falk, so I'm sorry.
I'll be brief. I will be brief. $3,000 signature bond through pretrial services. Stay away from Home Depot at 1570 Holcomb Woods Parkway in Roswell. No alcohol, drugs, and weapons. Defendant went into the store yesterday, placed a bunch of items in a cart, went to the return desk, used an old receipt to try to then return the items, got $164.93. One of the individuals, Curtis Fisher, who's an employee, lost preventions, tried to stop him from leaving. He pushed his way past him, tried to run, but was detained by the officer.
Any objection, Miss Hope?
No, no objection, Your Honor.
Right. Mr. Henry, per the prosecution, your bond's going to be set at $3,000. It's going to be a signature bond through pretrial services. You'll be required to report to pretrial once a month. And if you get arrested again for anything else, or if you do not report to pretrial, your signature bond will be converted to either a cash bond or a surety bond. You are to stay away from all your Home Depot stores, not just the one on Holcomb Bridge Road, from every single one. Understood, sir?
Yes, ma'am.
Thank you. Make sure your address is current with us and we'll send you notice of your next court date. No illegal drugs and no weapons are allowed. Thank you.
Due to the open case, that'll be per judge.
All right, I'll take the brunt.
Next, we have position number 14, Mr. Kenye Mays.
This is State versus Mr. Mays, 23 CR 002933B. Mr. Kenye Mays is accused of willful obstruction of an officer and battery from May 12, 2023. Mr. Mays, you've been advised of your right to remain silent, and your attorney is going to be Ms. Helen. Is this the case where Ms. Lee was waiting on?
No, Judge, that's Mr. Lee. I believe that's position 12.
Okay,
Yes, and that is a request for a breakout on that one.
all right, thank you. All right, any priors, Mr. Howard?
Second arrest, 2021 out of LA. Inflict corporal injury on spouse cohabitant. I think that was dismissed.
All right, thank you. Ms. Falk?
It does appear to have been dismissed, Your Honor. This incident happened yesterday at 800 Cherokee Avenue in Grant Park. Officers were dispatched out there because there was a call about a man beating a woman under a gazebo. A description of both of their clothing was given, and the officers observed the defendant yelling at Miss Kamaya Williams and throwing a sweatshirt at her while advancing towards her. They did match the description provided in the 911 call, so the officers announced themselves and the defendant fled, but was detained by the officers. Miss Kamaya Williams was questioned by the officers. She stated that the defendant was her ex-boyfriend. They had been arguing all day. He had grabbed her by her sweatshirt, punched her several times in the face. The officers were able to observe bruises on her face and her bottom lip. And a witness who was questioned, according to the police report, did state that they saw the defendant hitting Miss Williams. The state's recommendation is a $3,000 surety bond, no further contact with Kamaya Williams, 1 day anger awareness, no alcohol, drugs, or weapons. That is all.
Thank you. Ms. Helen?
Yes, Judge. Mr. Mays is 22 years old, Judge. Currently, he is a part of the CHRIS 180 program. I believe that does provide programs as well as therapy, Judge. He does have a high school degree that he received from Job Corps, Judge. He is from Detroit, Michigan. However, he's been in Georgia for the last several months. So I do believe he's a resident of Georgia. I don't believe he's going to abscond anywhere else, Judge. He does not have any children. However, he does have a permanent address in Austell, Georgia. That I can provide the state. I just don't want to put that in open court, Judge. I do hear his history. I believe that other case was dismissed. So with the allegations, Judge, and after speaking to Mr. Mays, I am asking for a signature bond, no more than $1,500, Judge, given his age. And again, he is addressing his current anger issues with the CHRIS 180 program. He is working, Judge, and he does believe that if he's granted that signature bond, he'll go back to work. He had an orientation with a new company for machine operation, about $15 an hour, Judge. So we are asking for that signature bond. We do understand for the no contact, Judge, but with Miss Kamaya Williams, Judge, but we do ask for that signature bond. We agree to the 1 day anger awareness class, but we are asking for the signature bond. If it's a surety, it'll be effectively a no bond for Mr. Mays.
And Your Honor, the state did omit a bond on the willful obstruction. We would be agreeable to a $500 signature bond on the willful obstruction for a total of $3,500 split.
All right, thank you. On the battery is going to be $1,500. On the obstruction is going to be $500. It's a $2,000 surety bond. No further contact with Miss Kamaya Williams to make sure you stay 200 yards away from her no matter where she is. No illegal drugs, no alcohol, no weapons and firearms. And his next court date is May 25th. And he also needs to stay away from Grant Park, the entire park. Thank you.
Your Honor,
Yes, sir.
like, may I ask for like some sympathy? Like, I can do community service. I've done community service for the CHRIS 180. I've also done community service for the Lost and Found thrift store. I don't believe that I am a person who deserves to have to stay in prison or in jail. I am very coherent. I am very understanding, but I don't believe that I'm a bad person to have to sit where I don't have funds to even do a surety bond at the moment. But I could do heavy community service if possible, something that won't deter me from the success route that I'm already placed on.
Mr. Mays, first of all, I'm not sentencing you. You are still legally presumed innocent of the charges brought against you. So based on your narrative, you seem to be under the impression that I'm sentencing you and having found you guilty. I have not done that. You are charged with these offenses, and under the Constitution, you're legally presumed innocent of these charges until the case goes to trial, where the prosecutor would have to prove the charges against you beyond a reasonable doubt. And that's why you have an attorney. Ms. Hogue has already argued for the circumstances under which you should be, Ms. Helen has already argued for the circumstances under which you should be released on a signature bond, and the prosecution has articulated their position. They have asked for a $3,500 surety bond. If you are accusing me of lack of sympathy, I am looking at this purely objectively under the factors with regards to how you should be released on bond. And presently, based on the factors, based on the information I received from the warrant, based upon the officer's observations, your bond presently is a $2,000 surety bond. The state had asked for $3,500. So it's not a question of sympathy. It's not a question of making you do community service. As I've said, you're not sentenced. These are just the terms under which you are released on bond. If you're unable to make bond, then you will remain at the jail, and we will see you on May 25th.
Okay,
Thank you.
thank you. Next, you have position number 20, Mr. Raymond Walker.
State versus Mr. Raymond Walker is under accusation number 23 CR 002936C. Mr. Walker is accused of giving false information to an officer on May 11th, 2023. Mr. Walker, you've been advised of your right to remain silent, and your attorney is Miss Helen. Any priors, Mr. Howard?
He got history out of Minnesota, Wisconsin, Illinois, and Indiana. Let me start with Georgia first.
Any crimes of moral turpitude, like false information, fraud, theft, and so forth?
Federal crime, those for drugs. Hold on. I said 2013 prohibited possession of a firearm and theft by receiving out of Wisconsin. Hold on. He got a lot of cycles out of Minnesota.
Does he have a out-of-state hold?
Not that I'm aware of.
I did not see one when I went to the jail system, which was surprising given the facts on this case.
I have a booking number under 230-5007, where he was
Hold
booked
on.
April 1st. Oh, that was on the hold. So I guess the hold must have been resolved.
Yeah. He had a 2016 arrest out of Minnesota, hold for the federal government. Yeah. That's it.
All right, thank you. Ms. Falk, what's your recommendation?
Yes, Your Honor. Our recommendation in this case, and I will fill out a little bit, he does have some offenses involving domestic assault in 2010 out of Minnesota. What I'm also seeing is a theft by receiving stolen property, where he was convicted in 2013. Another theft by receiving stolen property where he was discharged. Oh, that was the discharge from probation of the previous one. He also had a receiving stolen property in 2014 where he was sentenced. So there are a number of convictions for theft and for domestic violence in his history out of Minnesota. In this case, the officers were at the Skyland Motel at 2451 Old National Parkway in College Park looking for a defendant by the name of Mr. Greer. Inside the room that they were looking in, room 102, were 4 men and 1 woman. They were attempting to get the defendant's name, ostensibly, I believe, to determine if he was in fact Mr. Greer. The defendant gave the name of Joshua Jackson. The officer continued to look for that name and continued to look through the system for about 2 hours, and finally was called by the FBI, who called asking questions and then gave the officers the defendant's name and date of birth. It was discovered the defendant was on federal probation, which he is currently on for 174 months in 2021. And he was they also advised the officer that he should have been on an ankle bracelet, which he was not on. So the officers did not locate that on him. The state does have some concerns here, since he was apparently supposed to be on an ankle monitor. Somehow he got it off of his person. And we do have some concerns about his history, especially because he has 28 cycles out of Minnesota. And we are concerned for the lack of community ties. For that reason, we are asking for a $2,000 surety bond. It was currently set at $1,000. So we are increasing that, or asking for an increase in that.
All right, thank you. Ms. Helen?
Yes, Judge. Mr. Walker is 36 years old. When I spoke to him, he is aware of the federal probation, Judge. And that was not a charge dealing with theft or anything like that, Judge. So he is not currently working, Judge, but he does have his GED, which he did receive from prison, Judge. He's from Chicago, but he's been in Georgia for the last 3 years. So I do believe he's a resident. I don't believe he's going to abscond and go to Chicago or anywhere else. He has a daughter who lives here in Georgia with him. She's 17 years old, Miss Nazaria Walker. And I did hear his history in Minnesota. It was 2013, 2014. Judge, for the giving false name, we're asking for a signature bond of no more than $1,000 for this charge. Again, that's about 9 to 10 plus years without any issues with Mr. Walker. We'd be asking for a signature bond.
Bond shall remain a $1,000 surety bond, and he's to stay away from 5022 Old National Highway. I don't know if that is the
Skyland Motel.
Okay, if that's where he lives. Yeah, he can return there one time only with the police officer to retrieve his personal belongings. If there's a federal hold on him, or if there's non-compliance, that's up to the state to decide whether they're going to notify the authorities. Thank you. Next court date is May 25th.
Next, Your Honor, we have position number 12, Mr. Malcolm Lee.
That is the breakout room or position we're requesting, the breakout room with Judge.
Just out of curiosity, before we go into the breakout, Michael Rivers was also on the calendar. Is he present?
I waived Mr. Rivers' presence, but I did speak to him, so we are ready to go forward with Mr. Rivers when the court's ready.
Understood. Thank you, Ms. Helen.
So this is Mr. Lee, position number 12. And Sergeant Norrison, I would need you to place the courtroom 2 on silence. Please mute the screen. Mr. Lee is accused of battery, domestic violence, and 3 counts of cruelty in the 3rd degree from a January 9th, 2023 incident. Mr. Lee, you've been advised of your right to remain silent. Your attorney is Ms. Helen. Courtroom 2, could you place the video off as well until I return from the breakout? I don't want anyone conferring with Mr. Lee until his attorney is back in the main room. Thank you. Mr. Jordan, if you could place Ms. Helen, myself, and Ms. Falk in a breakout, please. Thank you.
Your Honor, if I may make a suggestion, Mr. Jordan just turned off the recording, and everyone in here is essentially either court personnel or literally here for Mr. Lee's case.
His mom is also here too.
Yes,
Right.
I'm here.
His mom
too.
is present. She's the affected person.
So, Ms. Helen, do you still need a separate breakout?
No, Judge, we can do it here.
All right.
You want me to stop the live?
We'll have to pause